Hi, I'm Dan Crane. I'm a professor of biological sciences at Wright State University in Dayton, Ohio, and I'd like to take advantage of the next 50 minutes or so to talk with you about how it is that DNA evidence can be used in courts, both within the United States and around the world. The PowerPoint slides that I'll be using as part of this presentation will all be available at www.bioforensics.com, and you'll also be able to find a number of other additional materials there that might help you get a deeper understanding of the things that I'll be talking with you about in the next few minutes. But with that said, let's get right to work and start talking about exactly how it is that DNA is making its way into courts in the United States. So let's talk about DNA technology in U.S. courts. First and foremost, we probably wouldn't be here talking about this at all today if not for the fact that criminal prosecutions for about the last 20 years now have been increasingly relying upon the use of forensic DNA evidence to secure convictions. And the reasons for that are pretty straightforward. Let's just go through the most obvious ones right out of the gate here. First and foremost, DNA testing is providing forensic scientists with absolutely unprecedented sensitivity. And at the same time that it's sensitive, in the sense that we can generate DNA profile information from unimaginably small quantities of starting material, it's also possible for these small amounts of starting material to generate very powerful, very probative evidence samples that prosecutors, again, are relying upon more and more. And more than just prosecutors, jurors are coming to expect prosecutors increasingly to provide DNA evidence to support their conclusions. So DNA tests have the advantage of being extremely sensitive and very distinguishing between individuals. But in addition to that, something that's making the use of DNA tests even more common these days is the fact that there are increasingly large databases available that can be used to help with the generation of investigative leads. I'm talking here about the situation whereby there's a crime committed with some evidence that's left behind at the crime scene, but where there is no good suspect that the police have been able to identify. In such a circumstance, it's possible to take that evidence from a crime scene, generate a DNA profile from it, and then compare that DNA profile to the DNA profiles that are on record for, at the present time, tens of millions of people who, for the most part, have been convicted of criminal offenses, but now increasingly are including individuals who have simply been arrested. So again, the idea here is that this is an opportunity to generate an investigative lead, where once we had no suspect, if we find that an individual in a convicted offender database matches an evidence sample from a crime scene, that may well provide a critical lead for law enforcement in investigating a crime. And in addition to that, it's fair to say that for the entire history of DNA profiling, the process has become not just more sensitive, it's also becoming much quicker and much less expensive to generate DNA test results. In the very earliest days of DNA profiling back in the early 1990s and late 1980s, it would often take months to generate a DNA profile. Today, a DNA profile can be generated in as little as a few hours, and there's a race underway right now for individuals to develop better and faster technology that conceivably might generate DNA profiles in as much as as little as a half an hour in the next few years. So again, DNA tests are fast becoming both cheaper and faster, and even more portable, to the point where it may be possible for a police officer at the scene of a crime to generate a DNA profile at the crime scene itself. So again, DNA evidence comes up all the time in courts in the United States, if for no other reason than the fact that the prosecution has found it to be such a very powerful tool in securing convictions. And increasingly, jurors are expecting that prosecutors will present them with DNA evidence in a wide range of cases, not just violent crimes, but even breaking and entry and extortion types of cases now are often associated with DNA test results. But that's not the only reason we see DNA evidence in court. Let's look to the next slide here and talk a little bit about the places that you might be able to get DNA evidence from. That'll give us some ideas about other opportunities to use DNA evidence. What we have here on this slide is simply a graphic that's showing a number of different ways that DNA could be obtained from different evidence samples. These are common household items for the most part, and you might be surprised to hear that it's possible to generate a DNA profile off of each of them, potentially a very useful DNA profile. Let's look at the comb in the upper left-hand corner to get things started. You can probably just barely see it on your screen, but the arrow might help you now to see that there's a little white speck there. There's a technical word for a speck like that. That's called dandruff, right? It's not a particularly revolutionary principle in forensic science, but that small speck of dandruff is actually a number of skin cells that have come most likely from an individual's scalp. And as we'll see in just a few more slides, a few of those cells should be sufficient to generate a DNA profile, and here that would constitute an abundant amount of material to generate a good solid DNA profile. And in addition to that one larger piece of dandruff, you see that the arrows here are drawing your attention to a few other spots that also have small specks of dandruff. Again, any one of those could well be a suitable source of DNA for the purposes of generating a DNA profile. But the elephant in the room on this particular slide isn't the comb or the toothbrush or the dental floss. Again, all fairly good and obvious sources of DNA, for instance, for generating a reference profile for a missing person. But the elephant in the room is this knife, and let's talk about that for a little bit. If we look carefully at the knife in the upper right-hand corner of the screen, you'll see that there's obviously some blood stains on it. And here's the funny thing. When a forensic scientist, particularly a DNA profiling expert, looks at a knife like this, their attention isn't the focus of their attention isn't the blood stains on the knife, and I think that actually ends up being for fairly obvious reasons. We often know precisely who the blood came from. There's usually a victim that is a very credible, likely source for those blood stains. And instead, what we're interested in is what's going on at the other part of the knife, where the arrow is pointing to here, that handle. DNA tests are sufficiently sensitive and sufficiently discriminating that it should be possible, and it happens all the time, for a swab to be taken of that handle, and that in turn to give us some insights in terms of who it is that might have been handling that weapon. And again, in a prosecution, that's usually the critical question. Who the victim is often something that both the prosecution and the defense can agree to. Who it is that was wielding the weapon, now there is often where the controversy is, and DNA test results can provide us with some insights in terms of who it is that might have been the person who last handled or most handled that part of the knife. But it doesn't end just with the prosecution's use of DNA test results. We need to bear in mind that DNA testing is also commonly invoked these days by the defense bar. This slide is showing you a picture of a fairly famous defendant from the early 2000s, as well as his lawyer. I'll let you guess which is which. One of these individuals is a prominent U.S. athlete, and the other is an attorney. If you're still wondering who they are, the tall individual is Kobe Bryant, and the less tall individual standing in front of him is his attorney, Pamela Mackey. Kobe Bryant was accused with rape back in 2003 and ended up relying heavily upon DNA test results to result in those charges being dismissed. He and the rest of the defense team had an alternative theory about the case, and the criminal defense at the time took the somewhat unusual but increasingly common step of generating DNA profiles from what the prosecution was suggesting would be important evidence samples. In this particular case, they took underwear from the woman who claimed that she had been raped, and the defense argument was that she hadn't been raped, but rather that she and Kobe Bryant had engaged in consensual sex. And what shored up that particular argument is that her underwear, the victim's underwear, in addition to having Kobe Bryant's DNA, which again is consistent with consensual sex or rape, also had semen stains and associated DNA profiles from other individuals, and that played into the defense's argument that this individual had in fact engaged in consensual sex, and then ultimately won the day for the defense. And why is it that that was useful for the defense? Well, ultimately it's because of the very same things that make DNA tests so appealing to prosecutors. DNA tests here, again, had unprecedented sensitivity. They were able to determine very helpful information from very small amounts of starting material, and they did it in a very discriminating fashion. So, while it works for the prosecution, those same advantages can also work for the defense. And in this particular case, again, it provided some support for, in this case, alternative theories regarding the case. And just as DNA databases can provide prosecutors with suspects for a particular case or a particular crime, DNA tests can also be used by the defense bar, searching those same databases to generate alternative suspects that, at the very least, sometimes raise important questions about reasonable doubt for a particular crime. So, what makes DNA testing so useful for the defense? I think the short answer is pretty much the very same things that cause prosecutors to think that DNA tests are such a valuable tool for their work. And it doesn't end there. All right, the topic of what I want to be talking with you about right now is not just how it is the prosecutors and defense attorneys use DNA in court, but rather how courts in general have come to rely upon DNA test results. And it doesn't end just with what's going on in court. Sometimes we have to talk about how DNA can play a role outside of court or after a conviction has been secured. And this next slide gets us to talking about the important work of groups like the Innocence Project, because DNA tests have increasingly played a role in post-conviction relief. Actually, just a few days ago, in September of 2012, the Innocence Project was proud to announce that they had accomplished the 300th exoneration of an individual who had been wrongfully convicted. They've used DNA test results to show that this individual here could not have been involved with the rape of his step-cousin. And there's an interesting backstory to this case, as it seems is often the case with the exonerations that the Innocence Project has accomplished. In this particular case, this individual was convicted back in 1994 and has served almost 20 years in jail for a crime that, again, ultimately it's been proven he had not committed. Again, the crime here being a rape and a murder of a step-cousin. Sadly, he had spent almost 20 years in jail, and perhaps even more sadly, much of the time that he spent in prison was actually on death row. And this individual is one of 18 now who have been exonerated, who have spent time on death row, but have been found to be innocent as a result of DNA test results. These post-conviction DNA tests have been extremely important. They've been telling us a lot about ways that the criminal justice system can fail, and sometimes forensic science itself can fail. I think it's important to bear in mind when we're talking about these types of post-conviction appeals is that we're not getting a truly random sample from the cases that the Innocence Project and other like organizations are actually looking at. There are 3 criteria that have to be met before the Innocence Project will actually go through the trouble of generating DNA test results for a convicted inmate. First, the individual has to have maintained their innocence throughout the process. There can't have ever been a recanted confession or anything of that nature. Before the Innocence Project will become involved, it has to be clear that this individual has been adamant about their innocence from their very first contacts to the very end of their interactions with the criminal justice system. And then in addition to insisting upon their innocence throughout the process, it's also necessary that DNA test results might actually provide some useful insights into the case. In Kobe Bryant's case, for instance, which I alluded to just a few minutes ago, the issue there was this consensual sex as opposed to rape? DNA test results rarely can give us insights in terms of which of those 2 possibilities is most likely, because DNA isn't telling us anything about the time frame or the circumstances under which the DNA came to be with the evidence sample. So, 3 criteria that the Innocence Project is looking at. One is the individual has to have asserted their innocence throughout. Another is DNA test results must actually help with deciding a critical issue for the trial. And third, and almost goes without saying, but still needs to be said, it's necessary that there actually still be material left for DNA tests to be performed upon. In the case of this 300th exoneration, the convict in that case, the exoneree, I suppose we should call him now, is fortunate that samples were still retained 10 to 20 years after the crime had occurred and after the trial had occurred. That's true for a very small fraction of cases that go back to the 80s and 90s. And again, you can't do DNA tests if there are no DNA materials left behind for tests to be performed upon. And so again, the thing here is that these DNA exonerations from the Innocence Project are looking at a fairly skewed sample. They're only looking at those that meet those 3 very specific criteria, and even still, they're telling us some very important things about our criminal justice system. For the purpose at hand today, again, I think it's clear that DNA test results are playing an important role literally at every stage in the process of the criminal justice system, from the point of bringing of charges to the presentation of a defense, all the way through, in some instances, to post-conviction relief. But as I've said, these exonerations that have been accomplished by the Innocence Project have brought to our attention a number of things that need extra attention within the criminal justice system. And this next slide shows some of the things that we've found to have been an issue associated with these different exonerations. Let me start at the beginning here by telling you that the numbers here add up to more than 100% because what we're looking at is actually a set of multiple instances of problems with some of these particular cases. Here's what's going on, though. Let me take you by the hand and explain what's happening here. In a total of the first 86 exonerations by DNA testing results, 2 individuals, Sachs and Kohler, went through and carefully analyzed the cases to find out how it is that an individual had been wrongfully convicted in the first place. Okay? And they found that in 71% of those 86 first DNA exonerations, in 71%, there were faulty eyewitness identifications. Right? People for years had been talking about eyewitness identification not being particularly reliable. And it turns out that these types of exonerations really illustrate that it's very commonly the case that an eyewitness has a faulty, or in some cases, a flat-out wrong recollection of what had transpired with a particular crime. I think it's interesting to look at the next bar, though. In 63% of the cases, again, sometimes we have wrongful convictions based on 2 or 3 or even 4 different problems, but in 63% of the cases, the errors ultimately were associated with problems with forensic science tests themselves. Now again, remember the restrictions or the criteria that need to be met before the Innocence Project would do DNA testing on a post-conviction relief case. There actually has to have been DNA test results that could help with the case. In each of these 86, the problem wasn't with DNA testing. DNA tests hadn't been performed in the original trials. Rather, we're talking here about problems with other kinds of forensic science, things like hair and fiber analysis, handwriting analysis, footprint or boot print analyses, things of that nature. Again, in over half of these 86 exonerations, individuals were wrongfully convicted based at least in part upon faulty forensic science test results, barring DNA testing. And then the list goes on. You can see that in almost half the cases, there were clear instances of police misconduct. Sometimes we found instances of prosecutorial misconduct. Sometimes forensic scientists, while they actually performed the tests correctly and arrived at reasonable results, misrepresented them when it came time to testifying about them. And again, the list goes on, including things such as insufficient counsel from a defense attorney, false testimony from some other individuals other than those associated with the criminal justice system. And for those who haven't been involved with the criminal justice system, surprisingly 17% of these 86 DNA exonerations did involve a false confession at one point or another in the whole process. So again, if you'd like to read more about this, this paper by Sachs and Kohler is published in the Journal of Science in 2005, and it's again based on these 86 first DNA exonerations. But let's move on. So DNA tests can be very helpful tools for the prosecution, for the defense. They can also be helpful in post-conviction relief. I think the question now is, well, what sort of things might be a reasonable source of material for generating a DNA profile? And the short answer to that particular question is pretty much anything. Certainly anything that comes in contact with an individual has a pretty good opportunity for giving us the material that we would need for generating a DNA profile. So that includes materials such as blood, fairly obviously, like the bloody knife we had seen just a few moments ago, but also things like saliva. The very first case that I was involved with that involved DNA evidence was back in 1991, and actually involved linking a defendant to a crime on the basis of whose saliva was on a cigarette butt that was found at the crime scene. Semen is very commonly a source of DNA evidence found associated with rape investigations. Bodily tissues, skin, liver, brain are obviously very good sources of material. And the bottom line, once again, is pretty much anything that comes in contact with an individual has some pretty good potential for having DNA associated with it that could be useful for the purposes of DNA testing. So let's get down to the nitty-gritty here and talk about just what it is that's needed to generate a DNA profile. Well, here's the thing. Our bodies are made of trillions of cells. That's right, trillions with a T. A big guy like me probably has somewhere in the ballpark of 2 to 3 trillion cells. Almost every one of those cells, and there are some interesting exceptions, but virtually every one of my cells and your cells contains within it a perfect copy of our DNA. That's our genetic blueprint. It's what it is that our cells are using to make the proteins and do the things that cells need to do to make us healthy, functioning individuals. So every one of those cells has a DNA profile within it, a complete set of our DNA, and there are trillions of those cells. We shed those cells all the time, hardly without thinking about them. So if I touch the podium in front of me right now, I'll leave behind a fingerprint, and with that fingerprint is typically in the ballpark of about 100 cells. Here's the thing. I didn't notice that I left behind 100 cells when I touched the podium. I have trillions of them. 100 is an insignificant number compared to those trillions. And here's the other thing. Pretty much every one of those 100 cells that I'll leave behind with a fingerprint will have within it a complete, perfect copy of my DNA, including the parts of the DNA that get looked at to generate a DNA profile. So simply having touched something is enough to leave behind, at least theoretically, what it is we need to generate a DNA profile. I'm going to bore you, perhaps, for a few seconds here by talking with you about some pretty intense numbers, but check this out. The human genome, the sum total of the DNA inside of each of my cells, weighs in the ballpark of 6 to 7 picograms. Okay? Tiny amount of material. In just a minute, I'll take you by the hand and talk with you about just how tiny that is. But each cell has about 6 to 7 picograms of DNA associated with it. The kits that are used by crime laboratories to generate DNA profiles recommend that the starting amount of material, the starting amount of DNA to generate a complete, reliable DNA profile be somewhere between 500 and 1,000 picograms of DNA. Right? Different kits vary. The kit that requires the least amount of starting material these days asks for 500 picograms as a minimum. Other kits ask for upwards of 1,000 picograms. You know what that works out to? Well, here's what it works out to. It's about 100 to 200 cells is plenty enough to satisfy the minimum criteria for any of the commercially available DNA profiling test kits that forensics labs use around the world right now. You know what that means in simple terms? Quite plainly, a single fingerprint should provide, a typical fingerprint should provide plenty enough DNA to generate a reliable, useful DNA profile. That's how sensitive these tests are. At a theoretical level, it's possible to imagine that you could get a DNA profile from as little as a single cell. In practice, the kits that are used to generate these DNA profiles are using just a single cell, typically many dozens, ideally a couple hundred, the amount of material you might get from a single fingerprint. So, I promised just a minute or two ago that I'd help explain and get you comfortable with the idea of what a picogram is. Well, let's talk about picograms here. You know, I tell you what, I'm a biology professor. I'm a molecular biologist, and even still, I have to wrestle once in a while with what it is a picogram is, because we don't talk in those terms that often, certainly not in our day-to-day lives walking down the streets. So let's put this in fairly simple terms. A packet of sugar. Everybody knows what a packet of sugar is, right? Many of you have probably encountered packets of sugar within the last 24 hours, either sweetening your coffee or just finding some laying around at a local restaurant that you've been to. But a packet of sugar, a standard packet of sugar, weighs 4 grams. That means that it contains within it 4 grams of sugar. 1/4 of 4 grams of sugar, pretty obviously, this isn't high-level math here, but 1/4 of a 4-gram packet of sugar weighs a gram. Okay, and that's going to be our starting point then for talking about what a picogram is. Because if you looked at that packet of sugar, you can break it up into quarters if you like, but when you're looking at that sugar closely, again, we all know that there are going to be individual crystals of sugar there. Each of those individual crystals of sugar weighs about 1/1000th of a gram. And scientists have a fancy way of talking about 1/1000th of a gram. We call that a milligram. Okay, so 1,000 milligrams equals 1 gram. 1,000 crystals of sugar gets you in the ballpark of about a gram of sugar. Okay, but we need to delve in deeper here. We can't stop with just talking about grams and milligrams. Again, we're looking to figure out what a picogram is. If you divided up a crystal of sugar 1,000 times, used an unimaginably small knife and microscopes and such to get a grain of sugar or a crystal of sugar chopped up that finely, that 1,000th of a crystal of a typical grain of sugar out of a sugar packet, that would weigh 1 nanogram. A nanogram is 1,000th of a milligram. But we're still not talking about picograms, because a picogram is 1,000th of a nanogram. How about that? If you do the math and you figure it out, that works out to a picogram is 1/1000th of a gram, 1/1000th of a grain of sugar. Better yet, 1/1000th of a gram of sugar. How about that? So that's the kind of quantities we're talking about when we're talking about generating DNA profiles. A billionth of a gram, a billionth of a quarter packet of sugar is how much DNA we're usually talking about dealing with for generating DNA profiles. Again, a typical human cell has 6 to 7 picograms of DNA within it, so 6 to 7 billionths of a gram. And a typical fingerprint will have in the ballpark of 100 cells, therefore approximately 600 to 700 picograms of DNA. Even the most sensitive commercially available DNA test kits right now are asking that, or at least recommending in their protocols, that a laboratory start with a minimum of 500 picograms of starting material. But at the very bottom end here, these are still incredibly sensitive tests. All right, so where have we been with all this? Here's the thing. DNA tests can get us reliable DNA profile information from all sorts of different materials, right? We can start with blood, we can start with saliva, semen, and so forth. The bottom line is pretty much anything that comes in contact with an individual has a pretty good potential for having DNA associated with it. If you're interested in finding out who it is that most recently wore a particular article of clothing, you might simply go to the friction points on that article of clothing, along the collar's cuff, for instance, or along the cuff of a sleeve, where the garment rubs up against a bit of exposed flesh. Those are commonly tested, but pretty much anything that comes in contact with that fabric has the potential to give rise to a DNA profile. We've already seen it: toothbrushes, dental floss, combs. These are all potentially good sources of DNA because those are things that come in contact with individuals, and what comes in contact with an individual often has associated with it some DNA that's suitable for generating a DNA profile. But there's another thing that needs to be borne in mind here, and that's this: the incredible sensitivity of DNA tests as we know them today is actually a double-edged sword, right? We need to bear in mind that when we generate DNA profiles, that we don't know anything about the time frame or the circumstances under which that DNA came to be associated with the object that's being tested. A few minutes ago, I touched the podium in front of me and I said, gee, look at that, I've left behind a fingerprint. I didn't notice that I left behind a fingerprint. I'm not missing any of those cells, right? They're trash, they're discarded. And yet, consider this. What if at some point later today, or in the next week or 2 weeks, a crime occurs somewhere near this podium? Maybe in a completely different room. I'm not sure how permanent the podium in front of me actually is. It may well be used in many different settings over the course of a week. If during the course of an investigation, though, somebody were to take DNA swabs to sample the podium in front of me, they may well find that my DNA profile is associated with this particular podium. How about that? I may have had nothing at all to do with the crime. The crime may have happened hours after I've been associated with this podium. You know, by the same token, the crime may have happened hours before I came to be associated with this podium, and yet there's my DNA profile. If I get identified as a suspect in a particular investigation and my DNA is found associated with a crime scene, I think we all know that the burden starts to shift toward me. That's a shadow of suspicion that I don't think anybody wants to have cast upon them, to have to explain how it is that their DNA came to be associated with an article, especially when you consider that, again, I didn't have any knowledge or expectation that my touching this podium might somehow someday be involved with some type of investigation. And I think it's easy to see then how it is that this could be a far-reaching type of problem for forensic DNA profiling. Again, I feel that I say this many times when I'm talking with attorneys, but it's important to bear in mind that the presence of a DNA profile on an object doesn't necessarily tell us anything about either the time frame or the circumstances under which that DNA came to be associated with what it is that we're testing. It could be that the DNA has been there for a few hours. It could be that the DNA has been there for a few days, a few weeks, in some circumstances even a few years. It could be that the DNA came to be there because it was deposited during the course of the commission of a violent crime. It might also be that it came to be deposited there simply by some very innocent contact that happened prior to or even after a crime had occurred. How long can DNA persist? Well, DNA, like any chemical, is subject to degradation. It can interact unfavorably with other things in the environment, but there are some DNA samples that we know have persisted for many millions of years. So in the right circumstances, DNA actually can be very stable, and it's certainly not unheard of to find that reliable, useful DNA profile results can be generated from samples that are over 100 years old. One interesting example of that comes quickly to mind is associated with Butch Cassidy and the Sundance Kid, male bandits from mail trains back in the Old West. Blood found associated with one of the mail bags that they had stolen was used ultimately to identify the remains of Butch Cassidy over 100 years after his death, his execution, actually. So here's the thing. When we're talking about forensic DNA testing, we need to bear in mind that there's all sorts of things that might be suitable for our starting material for generating a DNA profile. But because of the extraordinary sensitivity of the tests, it's actually possible for DNA profiles to have this sort of double-edged nature to them. And in one level, the great sensitivity can be a very powerful tool for law enforcement for generating investigative leads and probative evidence. In another sense, the defense needs to consider, might there be some innocent explanations for how it is that a particular DNA profile came to be associated with a crime scene? That double-edged nature of the tests becomes less of an issue when we're talking about larger and larger quantities of starting material. But for the past 10 years or so, there's been an increasing tendency for crime laboratories to attempt to generate DNA profiles from ever smaller amounts of starting material. And that is an increasing concern, this idea of innocent transfer. All right, well, so where are we going to go next with all this? I've talked with you now for about 40 minutes or so about how it is that DNA evidence can be and often is used in criminal courts, right? Prosecutors, defense, even post-conviction relief attorneys find that it's maybe one of the most powerful tools in their arsenal for uncovering truth and helping guide along jurors and judges to arriving at the appropriate conclusion for criminal cases. How do we get there? Well, ultimately, we're going to need to spend some time talking about how it is that DNA profiles get generated. And that process is actually surprisingly straightforward. I'll tell you what, it'll take me about 50 minutes to take you by the hand and tell you how it is that we can generate a DNA profile. I think you'll find that we have another video that speaks to that very topic. But in a nutshell, what's going on here is this. It's necessary right out of the gate to isolate and purify DNA from crime samples. At that point, an amplification step is going to be employed. Very briefly, it's involving PCR amplification. Following that amplification of the regions of DNA that we're interested in looking at, there's a size fractionation step. And at the end of all of that, there is some computer processing of the output of the data, and ultimately the need to break out some calculators and do some multiplication and attach some statistical weights to the results that get found. I understand that it may sound a little bit daunting coming into this all naively. Size fractionation, that sounds complicated in and of itself. PCR amplification, what's going on with that? But I assure you that the whole process from beginning to end can easily be accomplished in the course of a day. And it wouldn't take more than about 45 or 50 minutes to explain to you in fairly fine detail how it is that those DNA profile results ultimately end up getting generated. But that's for another time, right? For now, let me just recap briefly what it is that I've been talking with you about how it is that DNA gets used in court cases within the U.S. and abroad. It's become a very favorite tool of criminal prosecutors all over the world. It's also popular amongst defense attorneys, and increasingly so. In fact, I would like to encourage defense attorneys to be even more open to the idea of using DNA tests in the same way that prosecutors have found them to be so useful. Very often, it seems, in my interactions with defense attorneys, they're a little bit afraid when they hear that DNA tests are involved. Well, I think it's fair to say that the prosecutors were afraid when they first started working with DNA evidence. It's become one of their best friends over the past 20 years. And I think with a similar familiarity, defense attorneys will find that it's one of their best friends as well. And let's not forget about cases like the one out of Louisiana that I mentioned earlier, the 300th exoneration involving DNA test results. DNA testing is something that can provide very powerful tools as part of post-conviction relief as well. And whenever we're talking about DNA tests, I hope that one of the first things that comes to mind is these tests are truly the most sensitive forensics tests that are available to us at this present time. In fact, it's hard to imagine tests being more sensitive than DNA testing results are. Again, our bodies are made of trillions of cells. Pretty much any one of those cells is has got the potential to give rise to a DNA profile. And by the time we're talking about just a few dozen cells, certainly by the time we're talking about 100 or 200 cells, we're clearly in the range where we've got enough material to generate a reliable DNA profile. So there's great sensitivity. That sensitivity, particularly at the lower ends, comes with a price. There's often concerns that are associated with how it is that the profile came to be associated with a sample and when it is it came to be associated with a sample. But in terms of sensitivity, nothing has DNA testing beat for forensic scientists. And as I've just suggested with that sensitivity, that's a double-edged sword, and whenever we're talking about DNA profile matches and linking individuals to particular crime scenes and crimes, it's going to be important to think about alternative interpretations and alternative theories about how it is that the DNA came to be associated with the sample that has actually been tested. Bottom line, DNA test results need to be interpreted with caution, particularly when we're dealing with small amounts of starting material. All right, so that brings me to the point where I think we can wrap things up for this particular topic. Bottom line, DNA is widely used in U.S. courts and around the world. Prosecutors love it. Defense attorneys are beginning to embrace it more and more. Post-conviction attorneys have found it to be one of their single best tools for securing post-conviction relief. Literally hundreds of individuals now have been exonerated with DNA test results. It's an amazing technology. It has great promise. It's actually something that can be better still. And in the course of the next video or two in this series, what you'll see is not just how it is that DNA profiles get generated, but how it is that statistical weights get attached to them, and ultimately how it is that we can make DNA testing better than it is at the present time. All right, so I'm Dan Crane, and I've enjoyed talking with you for the last 45 minutes or so about DNA testing, and I hope that you'll look at some of the other videos in this series to see some of these other interesting aspects of forensic DNA testing.